Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We have covered 4 questions in this series, and in this episode, we will talk about the 4th question, which is holding interest in property. And specifically, we will be talking about eminent domain. So eminent domain comes from the takings clause, which says that government may not take private property unless there is a public use and unless the government gives just compensation. Eminent domain is the proactive condemnation of government for land it does not own and wants to own. The question in eminent domain cases is usually whether there is a public use. Okay, so that context brings us to Kelo versus City of New London, which considers this exact question. And here we are in the Supreme Court in 2005, about 2 decades after the Hawaii Housing Authority versus Midkiff case discussed in another video. The Kelo case took place in New London, a distressed Connecticut municipality with high unemployment and very low income. At the time of the case, the town had a population of 24,000, which was its lowest since 1920. To revive the town, the city decided through a local development corporation to develop, and through a renewal plan, 90 acres of a neighborhood in Fort Trumbull. There was a mix of uses called for in the plan: hotel, offices, residential. It would capitalize on a Pfizer facility to be built next door. To realize this plan, the city delegated its power of eminent domain to the New London Development Corporation. In the area where the plan was slated for, there were 115 privately owned properties. None of them are blighted, but the Development Corporation starts the process of eminent domain. This case was brought by 9 petitioners who own 15 pieces of property in that area. Justice Stevens writes the majority opinion. He restates the findings of the Berman versus Parker and Hawaii housing cases covered in the other video. He recounts that those cases were highly deferential to state legislatures and that the condemnations in those cases were held not to be unconstitutional takings. To use Berman and Midkiff as precedent, Stevens had to show how the facts were similar. Like Berman, there was a comprehensive development plan in Kelo. Like Midkiff, private parties would be benefited. For Kelo too, then, Justice Stevens says that economic development constitutes a public purpose that is reasonable in light of precedent. The existence of a private benefit does not itself disqualify a government action from meeting the public use requirement. In other words, the court will not second guess the city's determination that these properties were needed to effectuate the purposes of the plan. The city's exercise of eminent domain, in other words, was constitutional. So the majority takes care to say that they are not considering purely private takings which transfer property from one private owner to the other. They say there is no indication that the plan was intended to serve the interests of Pfizer or any other specific entity. Justice Kennedy's concurrence, also makes a pretty big deal about the city's actions not meant to benefit a particular private party. So here we see O'Connor, who writes one of the dissents, disagreeing. She says that the court is in fact considering the question that Stevens says it's not considering, the question of whether property can be transferred from one private owner to the other just because it might be upgraded. She says, this is a famous line from her dissent, quote, "Nothing is to prevent the state from replacing any Motel 6 with a Ritz Carlton, any home with a shopping mall, or any farm with a factory," end quote. She also says that government may only take property and transfer it to private parties if the initial taking eliminated some harmful public use. She tried to distinguish the Kelo facts from the facts in Berman and Midkiff. Justice O'Connor argues that in Berman, the blighted neighborhood was injurious to public health, safety, morals, and welfare. In Midkiff, the harm was extreme inequity in land ownership. By the way, a reminder that she wrote the unanimous opinion in Midkiff. In Kelo, she says there's nothing that indicates that petitioners' homes create any harm. Stevens responds to O'Connor's complaint by saying that harm has never been the Supreme Court's concern. The Berman case, for example, didn't involve any harms. The store wasn't even blighted. Someone could have argued that the very fact that these property owners were holdouts was a harm. They were preventing the city from realizing an overall development plan that could have transformed New London. What happened with the Kelo plaintiffs instead is that they ended up like little houses in the middle of a wasteland. There was some negotiation, and they did walk away with some compensation for the condemnation of their property. The planned development, however, was never built. With all the delays of litigation, probably became less feasible. But the aftermath of this case went much farther than the original plaintiffs or the city's dashed dreams. That is the subject of another video. But I will leave this one just right here. I would love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.